Okay, hi there. Good afternoon, good morning, and good evening to wherever you are tuning in from. It's my pleasure to welcome you to the ICLG webinar on digital health. As a quick introduction, I'm James Strode, the publisher for the International Comparative Legal Guide to Digital Health for 2023. Today's not about me, today's about the panel that we've managed to pull together to really discuss a little bit more about what's going on in the digital health industry for newcomers and, of course, anyone that's playing an active role at the moment. The digital health industry was thrust upon us into the forefront during the COVID-19 pandemic. We went all to virtual waiting rooms and to telehealth as the lead way to get any sort of medical help during the pandemic. Now, with all of that, there's been a huge influx of entrants into the market, from software designers to pharmaceutical companies, life science companies, providers, and of course, patients. It's predicted that the digital health industry is valued at over 200 billion USD at this moment in time. And by 2030, that will have risen to 800 billion USD. So we can see that there's huge change within the industry, breakneck speed of innovation and influx into the market. And of course, with all of that comes hurdles, comes challenges. And that's why we've come together today to produce this webinar, and alongside the webinar, produce the International Comparative Legal Guide to Digital Health to help us overcome the legal challenges that we all face. And I hope you'll find today an interesting hour for you guys at home. I'd like to introduce the panel briefly. We've got Lincoln Sang from the law firm Ropes & Gray. Lincoln is a partner at the firm and also head of the European Life Sciences Group. Next up is Christian Lopez Silva. Christian is a partner and again, head of Mexico's healthcare department. We've also got David Wallace of Johnson & Johnson. David is the leader of the healthcare technology group within J&J. And finally, we've got Roger Kuan. Roger is at Norton Fulbright and is US head of precision medicine and digital health. With these four together, we've created a panel that will provide high quality insight within the digital health space across multiple jurisdictions and continents. Before I hand over to Roger, who will moderate the hour's session, I'd like to extend my thanks to him, but also to every other contributor who has helped come together, collaborate, and produce the ICLG Digital Health publication. Roger, I guess for you as our contributing editor to this treatise, I would love to just hand over to you a little bit to explain to everybody who's tuned in whether or not they're familiar with the publication or not, a little bit more about what to expect within the publication this year. So I'll hand over to you, Roger, if that's okay.
Sounds great. Well, thank you, James. Well, we're very pleased to see that this year the guide's coverage is expanded to 21 jurisdictions, including new content, chapter content from Australia, Portugal, and Belarus. The new jurisdictional content that we've included here in this year includes additional coverage for regulatory issues and also data issues as well as IP. And it looks like, and we looked really deeply into the role that AI machine learning is beginning to play in this digital health marketplace. And some of the expert chapters that we've included in this year's guide cover some of those issues. For example, some of these new topics go around data sharing protection, product liability within digital health, and digital health products, amongst others. And we also have this very interesting write-up on basically investing in digital health, given that right now we are in a, I guess here in the US, we are in the throes of about to enter into a recession. So a lot of these topics or this discussion around investing is probably very useful for some of the companies that are looking to go in this area.
Thanks, Roger. Appreciate that. And David, while we've got you here, and I don't mean to spotlight you too much, but as in-house counsel, I'd be grateful if you could tell everybody why you support the publication, who should be picking it up, and really where you see the benefits of this come from, if you don't mind.
Yeah, I think Roger set it up great. There's this convergence of applications of technologies that have been around for quite some time. And you've got the business teams, so companies like J&J and other large companies trying to translate data and software to value in commercial models that we haven't seen before. What that leads to is a lot of risk. And then how do you identify great opportunities and manage that risk while you have all this swirl of jurisdictional changes, evolving frameworks for how you manage intellectual property and how you look at that, all within the context of data. And what that does, if you're an in-house counsel, it's like, how do you go to a resource where you can translate that risk into practical guidance for your business partners here? And that's what the guide is really, really good at. It provides not just an understanding of the technologies and the legal issues, contextually wraps them together, but also gives you a way to realize that you're not the only company facing these. Oftentimes as in-house counsel, the question that comes up is, are we the only ones facing this? So getting out and seeing that these are common issues. And I think the other side of this is data is global. So jurisdictional issues and data go hand in hand. And that's one of the things that you can be in the US, but you have to look to Europe, you have to look to Asia Pac, you have to look to LATAM, because data is coming from everywhere. So that's why the guide is so informative, because of its ability to pull that context together to help you understand how to apply it, that you're not the only one facing this. There are other companies like you, and you can get that from the guide. And also the reach is global. And having the jurisdictional experts called out in that guide is a great way to say, who can I partner with to sort of navigate while I identify opportunities and manage these risks globally.
Thanks, David. Appreciate that. Look, I said it's not about me. It's about you guys on the panel. And I'll hand over to Roger in a brief moment. I just want to let everybody know that post this webinar, whether you're watching live or you're catching up on record, you'll all receive a complimentary download of the full publication for you guys to read, take away, share internally within your companies as well post this webinar. So hope you enjoy it, hope it's useful. And without further ado, I'll hand over to Roger to moderate and get into the content that you're so looking forward to.
That's great. Thanks, James. As James mentioned earlier during the introduction, during the COVID pandemic, we saw a really rapid adoption of digital health solutions throughout the healthcare industry, and a lot of investments has piled in as well. Part of that involved actually glossing over a lot of, I would say, issues with digital health and how it's adopted and implemented within healthcare. So one of the first questions I really want to pose to the panelists is, what are some of the hot topic issues, these issues that were kind of glossed over in the last 2 or 3 years that you're seeing and encountering in your various jurisdictions?
Lincoln, would you like to begin?
Happy to do that. Thank you very much, Roger. I think that one single topic that I can think of is common to both healthcare delivery and for the industry. David is really in the co-phase of it, is the overall efficiency drive to deliver healthcare more efficiently and more patient-focused. And insofar as industry is concerned, is to be a lot more responsive to what the external stakeholders want, and which is to develop drug more efficiently, or devices for that matter, more efficiently. As a result, a lot of the machine learning and AI have been increasingly being applied into healthcare delivery. I think you highlighted the COVID situation, but now COVID hopefully is over, but now people have to refocus on exactly how those converging technology, focusing on the amalgamation of physical science, biological science, and clinical medicine, and mathematical modeling in maximizing and optimizing patient care. And for industry is how they can use those converging technologies to do better trial and bring new products and more target therapies and precision medicines to optimize patient care. And that is really the focus of what I would say is the hot topic. Obviously, there are other issues flowing directly from that proposition.
Yeah, I can build on what Lincoln said. I think one of the hot topics is there was a lot of focus on technology and I'll say hype and jargon, and less focus on business fundamentals. I completely agree with what Lincoln said. It's one thing to have the technology, but it's another thing to say, well, how are we monetizing this in a real way that's going to drive efficiencies, because efficiencies lead to cheaper clinical trials. Cheaper clinical trials lead to probably more affordable therapeutics that can address a broader group of people and get there more quickly and be more accessible. Those business fundamentals do not change. You still have to have a very strong pipeline before you can invest in these other technologies. I mean, the fundamental science is still very, very, very important. I think it always will be. And I think the companies that are focusing on how to translate that technology into incremental improvements to the fundamentals are going to do much better, as opposed to sort of chasing the rainbow like I see a lot of companies doing.
What we see in Baker all the time, and this is Baker Mexico, but collaborate with other colleagues all the time from other jurisdictions, is that there is a lot of activity in this area. We have had to organize ourselves in the best efficient way as well. For lawyers, digital health also triggers a number of areas. So it's not a single area. So for example, you have regulatory issues in relation to information technologies, but also health regulatory issues. What we have found, for example, is that there is a lot of, lack of knowledge on the health regulatory side. There's a lot of knowledge on information technologies. Many of the clients are aware of the implications, but less so when it comes to health regulatory issues. So we have had to bring together, for example, two different groups, those that are into our information technologies practice areas, and then the area where I am, which is a health regulatory area, and then work together and be able to also communicate smoothly with the clients who do not divide their applications into different fields of law. They just want to get it done, do their business, and we need to also understand from my health regulatory perspective also what are the implications on the information technology side, so that we are using similar language, so that the regulatory experience or the legal experience for the clients is also a more friendly experience, which is replicating what all the players are doing here in digital health. They're trying to improve, as Lincoln was saying at the end, the experience for the user, right? So that, for example, with telemedicine, we see it all the time. Clients come and, for example, lots of startups, they want to improve the experience for the patient and start connecting different aspects of the telemedicine experience and end up connecting different implications. For example, a telemedicine platform quickly will pick on electronic prescription, will pick up on telepharmacies, will quickly pick on electronic health records, and so on. So integrating all in a smooth way can be challenging as well for us as advisors, but we're happy to do it. It's a fascinating area. What kind of topics do we see? And these have been developed in the guide. Well, telemedicine, as I said, medical apps is an area that I haven't mentioned that is picking up quite quickly. And lots of different tools, diagnostic tools that are built into medical apps. this has represented a challenge for regulators all over the world, and certainly in Mexico. They have struggled to understand what to do with it. There are international harmonization efforts on this regard, and luckily Mexico is looking at those. So, for example, the International Medical Devices Regulatory Forum has been developing and working on the notion of software as medical device, and Mexico is picking up on those, developing that concept, looking at the international standards in that regard, and any harmonization is obviously welcome. Mexico is part of Latin America, more geographically and historically, although not so in terms of economy. We're much closer to the US and what's happening there, but we tend to be located by clients definitely as part of Latin America. And what we see there in Latin America is as well that is not harmonized. When clients look at Latin America, they will like to see something that resembles like the European Union, like, yes, a number of different countries and jurisdictions, but more harmonized regulatory, and we do not have that. And so any harmonization effort is welcome. Mexico has been taking that direction. One hot topic that I could perhaps overarching trend that I could highlight would be that there is a strong interest in promoting the notion of regulatory convergence, which has been picking up in regional trade agreements, which in itself is a trend. And Mexico has been actually from that taking the notion of regulatory reliance. And regulatory reliance is interesting because that recognizes that if an approval has been issued by a high standard foreign agency, it can be recognized in Mexico. And so to be able to enter into the market more quickly. So it is very interesting what these regional free trade agreements are doing, are impacting digital health, because they tend to nowadays include a chapter on health regulation and a chapter on digital technologies as well. So it's opening very interesting possibilities. The digital technologies are being picked up quite quickly as well by the users. There has been a couple of studies done by different, for example, the Mexican Association of the Internet, and then the FunSalud, which is a foundation, a think tank, and they have been measuring the uptake of the technologies by physicians and by users, and it's quite high in relation to telemedicine, for example, or with the interest in telepharmacy and so on. So there is a lot to be said. There's a lot of things going on. And I think that this guide, and I appreciate that we were invited to participate in this version. I know that there has been a number of versions already and a number of lessons learned there. And I suppose that this guide reflects all of that. And for us as well, we saw it as a very comprehensive effort, lots of different areas. That's why we had to invite 4 different co-authors, and I am just one of them. So happy to be here today.
Great. Hey, playing off some of the remarks made by the panelists today, I mean, a lot of new technologies, very cool and innovative technologies that are being implemented within digital health. Are you guys seeing any type of divergence in terms of adoption of these technologies between what I term as back-end digital health technologies? When I'm thinking of back-end, I'm thinking about technologies around maybe handling the data, storing it, and sharing data in the back-end between systems, and digital health technologies that are being implemented in a more kind of patient-facing, meaning these are diagnostic tools or any type of patient monitoring tools. Do you see a divergence in the adoptions in your various jurisdictions? Because here in the US, I think the back-end systems are fairly, there's fairly uniform agreement that they're good, and I think the adoption is very rapid, but on the patient-facing side, there's been some challenges.
I think, Roger, you picked on a very interesting point, which is extremely important. I think that what we have seen over the years is there's a greater willingness of the authorities, because the sector itself is highly regulated, be it in the industry sector itself or the healthcare delivery sector. I think the sector itself is highly regulated. But insofar as the life sciences industry is concerned, there is a general willingness of the authorities to cooperate, to set out best practices. The point of reference is really the collaboration between the UK agency, the US FDA, and Health Canada in developing the good practice, or best practice for that matter, in machine learning. And in that particular guidance, it sets out very clear guidance about the importance of transparency. Because one thing that I think that one will have to recognize, having worked as a regulator in my previous life, I have to recognize, and I think hopefully that people recognize that the law usually trails behind the technology, and the technology is moving extremely fast, and the legislature and the regulators may not necessarily move in the same pace. And when you say divergency, most likely to be the fact that people are still catching up at a different pace in terms of implementation. Exactly how we're going to regulate this particular technology? Is it really a product, or is it a service? And that will turn on not only the way that we regulate this type of converging technology, and also it brings about new challenges in terms of product liability law as well, because as you know, that strict liability law applies to product. It doesn't really apply to services. And one may characterize as some of the applications we are looking at really doesn't fall within the realm of product in a sense of product liability. So it raised new challenges for the lawyers and as well as regulators and legislature.
That's great. I'm like, now touching on a point that I think David raised earlier about monetization, right? How does everyone on the panel see reimbursement playing a role in, I guess, either increasing or as a barrier for adopting a lot of these digital health tools and technical solutions?
I think it's a great topic you have highlighted insofar as reimbursement is concerned. The normal approach for reimbursement is really about reimbursement of a particular product and not necessarily to a particular technology platform or service itself. But the underlying principle can be adapted to pricing reimbursement. The two components one will have to be mindful of are essentially the clinical effectiveness or application and the patient aspect of the utility of the application in optimizing patient care. And that clinical effectiveness estimate is no different from the clinical effectiveness or relatively clinical effectiveness that the HTA Health Technology Agency tend to apply. That is the first component. The second component is really the cost effectiveness component. And the way we approach on this side of the pond in Europe is to look at the incremental benefit to see whether or not the price point that the manufacturer is seeking to establish is really an appropriate price point, and the willingness of a given national health system can afford to pay for. These two components are not new components, and those are the components that routinely apply in health technology appraisal anyway. So I'm interested in hearing David and Christian perspective.
We're very similar over here, and I think it's one of the sort of the low-hanging fruit would be something like companion diagnostics. And how would you go about doing that? I think the challenge has been really just getting the stakeholders to understand the technology. And because without that, you don't really get to that discussion about what the nature of the reimbursement needs to be. And I think that's been one of the things that slowed it down a bit. I mean, you've got both the companies themselves that are struggling with how to apply it, making sure they understand it, making sure that they can actually generate profit from it. But then you still have to walk it back to all the regulatory agencies and the legislatures and everyone else to make sure that they have a fundamental understanding of what the technology is and why this should be reimbursable. And I think oftentimes we'd like to miss that step and just arrive there, but we get there only to have to walk it back and make sure you build that consensus. So I think that's going to there's going to need to be more of that and make the technology sort of less hype and more sort of practical.
Yeah.
Well, in Latin America and in Mexico, what we're seeing that is that the notion itself of reimbursement is not as familiar to these jurisdictions. So for us, how the government acquires products and services is done mainly through the regime of public procurement. So the notion of reimbursement is not as common for us. You would have to look at it in terms of are you looking at the private market and the reimbursement that it entails in terms of private insurance and so on, or the public market. And there is a sort of co-payment to the extent that the public health system is funded both by employees and employers. And to that extent, there is a notion there of co-payment. But in general terms, you do not have to go through the process of having something evaluated and concluded upon to see if it will be reimbursed or not. So it's a very different discussion for us. To that extent, it's a matter of how the government whether the government has a known policy on specific areas. So does it have an agenda, a national plan on digital technologies? Does it have a plan on artificial intelligence? And does it have a plan on medical technologies in general, and so on and so forth? And it's more complicated to push for those agendas at the same time. For that reason, many of these discussions tend to be centralized by the regulators. So, but that's only one player of the whole system. We tend to have multiple players. We've discussed before this, Roger, that many of the jurisdictions entail not only looking at one main regulator, but actually a number of them. And then you have to look if the jurisdiction has a federal organization, or if the states have a stronger role, like in the US. The influence of the state regulation is way higher than it is in many other jurisdictions, like in Mexico, where the health regulation is mainly federal. So you only have to worry about that and not about the 32 other states and their local regulations. I would just like to go back a little bit on what's something that Lincoln emphasized, which is it is a very interesting time for lawyers, because when something is in the early stages of being regulated, and these technologies have been here for a long time, to the extent that we have lots of literature. I studied in England in 2002, 2008, so a long time ago. And the notion of converging technologies was already there. We were interacting with colleagues like from the health side, from the information technology side. So lots of it was already there, but the regulation hasn't picked up that quickly. The market has, the technology has, and the regulators haven't either. So they're struggling. And for lawyers, it's important that we participate in those discussions and help the regulator understand what are the correct analogies, because they tend to make the wrong ones. So I don't know if I didn't take classes of theory of regulation, and actually here is critical, because they tend to want to regulate this as something, for example, that is more risky than the regular, for example, provision of health services. In Mexico, there is a draft initiative, law initiative, where they want to have the platforms for telemedicine being subject to a prior authorization from the health regulator. And what we've been saying is that, well, 80% of the cases for consulting rooms, so health services, are not subject to one. So why do you think this should be subject to one here? Where's the justification of that? And there's a whole of theory of regulation behind that should be given visibility to reach some good outcomes, because over-regulation could also kill digital health.
Interesting. Playing off of something that you said earlier, Christian, regarding the idea of convergence and harmonization of global regulatory requirements and how they apply to allow, to these type of tools. As we all know, AI and machine learning has become a very hot topic item within digital health. I mean, actually within any technical area that we're playing in right now in general. And, any type of AI machine learning solution really necessarily is tied into data, right? The amount of data and the heterogeneity of data that's available to go ahead and train these models. Now, I do know, that there's a number of companies, especially companies with I would say, footprints in multiple jurisdictions and countries. They may or may not be considering bringing in data from all these various jurisdictions, right, to train these models at one location. So I'll kind of frame it from the U.S. perspective, right? Here in the U.S., generally speaking, HIPAA applies from a privacy side to all health data, right? But what we're seeing here on from a state perspective, is that every individual state in the United States is coming up with its own legislation that is, in a lot of ways, more restrictive on what the HIPAA requirements are. So I'm interested in hearing your thoughts as to whether or not there's any type of movement, or you see that there's some convergence on, I guess, the regulatory requirements for data as well, because I feel like the most powerful uses of again, especially AI machine learning powered solutions, is when you can agglomerate and put together data, as much data as possible. And oftentimes that's going to come up from multiple jurisdictions around the world.
Well, we do not yet see that kind of convergence taking place. We still see these two main points of references. So the US, or North America, and Europe, to put it like that. And then countries aligning to any of those two, or finding a point in the middle. And Mexico is doing that. It's finding a point in the middle. So in some respects, we have stronger regulation, privacy regulation, than the US. And in some regards, we are heavily influenced by the European regulation, or the approach towards this. There is a strong foundational basis on human rights as well. So that on its own is taking its particular trend on how to address these issues and how to satisfy the rights of the holders of those rights to the information. We do not tend to see, so there are solutions that, for example, respect consent, but do it in different ways. So we see all the time discussions about where the server is going to be located, where is the data going to be stored, how the processing of the information is going to flow. And then we have to look at those other jurisdictions and understand what are the restrictions. So and those decisions actually influence immediately the business model that the client is bringing to us. So we're not there yet, I think, in terms of global harmonization. It would be good to push for that. That's what happened in the health regulatory side. And what has happened, as it happened with intellectual property at the time, it was the free trade agreements, which became the tool for that. Because if you just wait for there will be international fora to discuss these issues. But if you wait for those international forums to mature enough and quickly enough to come up with an international treaty on its own, it's not going to happen. So the quickest option is to trigger that discussion within the free trade agreements.
Great. Now, I'm interested in your thoughts, Lincoln. And the reason I'm kind of, going to you with this is that the UK has the UK Biobank, right? And basically, I think they initiated a program several years ago about doing whole genome sequencing broadly across the population in the UK. I can definitely see in the coming years the value in the UK Biobank, and from two perspectives. One, UK has a largely heterogeneous population. That's the first part of it. The second part is that you have institutionalized healthcare that makes pretty much all the, I would say, medical records being harmonized. And again, those two combined together makes for some very compelling data sets for a lot of countries to use. So I'm interested in seeing, do you have any thoughts on how the UK, because I can totally imagine how companies are based outside of the UK in various countries are going to look to try to get access to this data. And from the UK's perspective, I'm curious as to you have any thoughts on regulations that are going to restrict the outflow of the UK biobank data outside of the UK to other countries?
I'm not too sure that it will affect the data sharing as soon as the data incorporate into a completely anonymized format into a data bank. UK is not the only place where we have a biobank. I mean, Norway has a very good and a very well run and repository of a biobank as well, which is very well known. And I think that there are a couple of things that one will have to be mindful of is the source information itself and then the downstream data management. The source information itself is quite critical because I think, as you rightly pointed out, about the homogeneity and heterogeneity of a given population as to whether or not the data you have accrued in this particular database can be used in a generalizable way for the purpose of, for example, constructing the algorithm to minimize algorithmic bias, things that I think the David company perhaps will be interested in to facilitate and streamline clinical development program. And that begs the question of data transfer of personal data, as you rightly pointed out, I think alluded to by colleagues, is that will present challenges because there is no harmonized approach in terms of transfer of personal data on a cross-border basis. Very often, people are looking at the European, now the UK actually has implemented the European law, even post-Brexit, the General Data Protection Regulation. And most recently in China, they have developed its own primary legislation, which essentially mirror image of the European approach. That is one aspect that will present challenges in terms of data collection as a source data. The second element, which I think we just discussed, is about the repository. How are you going to manage the repository of data in this biobank, and how are you going to share that? I think that the sharing of the anonymized data probably present less challenges, so long as that the originally informed consent form is sufficiently robust. And the UK approach has always been that so long as the informed consent form is sufficiently enabling, that will minimize the issue for secondary analysis. And that has been accepted by the UK regulatory authority, the major charitable organization like the Medical Research Council, and that has been the approach taken by the UK researchers, guided by various good practice guidance. For example, the Health Research Authority in managing and data collection and the creation of data repository.
Yeah, and that's interesting. I think that's one of the advantages that the UK has, right? Because it has a nationalized healthcare system, that you can kind of standardize how that informed consent, at least the terms and the way it's explained to patients in a more uniform manner. Here in the US, as you know, we have a very fragmented healthcare system, and every player handles that slightly differently. And I think we're having definitely seen some issues here. Staying on the topic of AI, now, this generative AI has turned into again, this really hot topic item recently, right? So I'm curious, from David, from your perspective, how does on the industry side, what are your thoughts about generative AI and how it's going to be implemented within healthcare?
Yeah, it underscores and hopefully incentivizes companies to have a really, really good data governance policy. Everything that Lincoln said about the jurisdictional issues, the informed consent issues, and when you step back and look at that, you say, well, data feeds this pipeline of innovation, whether that's traditional computational tools or generative AI tools. The tools are sort of downstream, and you still need a mechanism to ensure that you have the proper governance in terms of how you access, how you use, and how you share. So to me, if I look at whether we're using, some type of tool with respect to like an instruct model, like a chat GPT or something like Copilot, or, even solutions from third parties. I mean, NVIDIA has an amazing suite of, life science, drug discovery, generative AI tools. All of that is great by itself, but you still have to apply it to generate revenue in a way that's not going to create unnecessary and inappropriate risk. Without an appropriate data governance plan and a great data governance team with the right technical competencies to reach out and understand, when you contract for the data, how do you bake those rules into your data access such that the data migrates downstream, and this process, those rules go along with it. So whether the consent was appropriate is going to be different depending upon the downstream use. You need a way to bake that in early enough so that we mitigate those risks, because our stakeholders, our data engineers, our data scientists, our product development teams, we really can't shift that burden on them to understand all the operational obligations of that data use. That's where legal and regulatory partners and everyone else, the risk stakeholders, have to be involved in making that process efficient in a way that the business can monetize and commercialize and hopefully make this, a successful service or product. And so to me, generative AI is no different than that. I just want to make sure that, what we're doing here doesn't lose sight of the fundamentals. You need that infrastructure in place, whether it's Gen AI or the next technology. You still need an amazing governance process to be able to sort of translate that into value.
So that's interesting you brought that up on the governance side. I mean, now you see in the media, right? There's a lot of very gloomy, doomy type of talk about how generative AI is going to create all this chaos. Do you see the governance issue being unique because it's generative AI versus traditional? I'm just curious, again, how much of it is hype that there is this unique issue that's unique to generative AI, and how much is from a reality perspective? How different really is it?
Yeah, I think it does create different, it kind of amplifies existing issues. So for example, if we're talking about open source compliance, using a tool that allows people to generate code more efficiently and probably quicker, which means we're potentially distributing more code that, depending upon where the data was sourced from, here it's code. If there were licensing compatibilities, now you've just increased that exposure, right? So now you have to figure out, from an operational standpoint, how do you manage that risk? So do you shift the burden to the Microsofts of the world and say, hey, look, we need a better mechanism to track and trace, what was generated and what was labeled? So I think that's probably a real world issue. I think the other side is, as the legislation is maturing, we're likely going to see some type of requirement to say, if AI is inside, we need to label it as such. And I think generative AI, because of maybe the desire to not be left behind, there's an increased appetite to start jumping on the train and using tools and apply them. I think there's some, if people could take a beat and just say, okay, that's great, still goes back to governance. If the legislation changes such that you have to label the output of something as being from some type of AI, how are you going to go back and do that from an evidentiary standpoint? And then we're seeing the other things is that you're seeing a lot of these copyright cases and other class action cases related to Gen AI. So you can see the legal framework is still trying to mature and figure out where the liability sits. I think from an evidentiary standpoint, you still want the ability to track and trace, and what to me goes back to governance. So if it just personally, I think that the wise thing to do is to make sure you have, once again, that infrastructure in place. I do think certain aspects of Gen AI are going to expedite the creation of more risk without, if you do it in a way where it's not, you're not using the technology in an appropriate fashion because you're getting out in front of, well, I don't really have the infrastructure in place to make sure that if I needed to show some evidence of how I'm using it, transparency, what have you, that I could go back and do that.
Great. Christian, I think you had something to add?
Yes, thank you. I wanted to add something on the issue of artificial intelligence, and perhaps I would put it like this, like an old issue and a recent issue. Like 5 years ago, and that's old now, but and it's amazing that it's old. The discussions about artificial intelligence in practical terms, for example, what I saw was that when IBM Watson came to Mexico and wanted to explain the technology to the public health institutions, and so that they could analyze if they could adopt it more widely. And if you're familiar with what they do, is to offer a very comprehensive tool that that curates a lot, uses curated information so that it supports the diagnostic part, the decision, the treatment decision, identifies potential clinical trials that may be available. So it's a very comprehensive tool. And what we saw was that the physicians were not correctly understanding what it meant, regulatory speaking. And the commercial teams as well, and this is not only for them, but for all the clients that we see all the time, they tend to describe what the technology does in inaccurate terms, for example, or in ways that could create risks for them. So who's doing what, for example, in relation to a platform that learns on what it does, that it's in the healthcare sphere, and that, well, usually supports the physician, but does not substitute the physician. So Lincoln was already saying, well, the distinction between product and service, and product liability obviously relates to product, not to services. But then with services, you also have the negligence regulation, right? But it also applies to human beings. It does not apply to equipment. That is, so only humans can provide the health service can provide. So that it's a whole area of discussions that was happening 5 years ago. What has happening very recently in relation to AI, for example, was that with medical apps, well, used to be just a medical app, but then now they tend to have functionalities that would allow it to learn what it does, so making it an AI tool. And for regulatory purposes, that's a very complicated thing to address. So what do you mean? Are you collecting new data of the users for improving the product? That's the definition of clinical research. So which is subject to approvals, to separate approvals, to ethical approvals and to regulatory approvals, right? So it's like, how do you frame that correctly, and how do you communicate that to the clients so that the clients are not themselves describing what they do in the incorrect way, so that they get in trouble or create the risks improperly. So that's something that more like a recent issue in relation to artificial intelligence. And I would just add something before I don't have the opportunity. We're running out of time, but it relates to the guide. I thought that the guide was very, it was very positive that it included a mini section on the commercial agreements and how to reflect everything that the rest of the guide says, right? Because at the end, and this is something that David was mentioning, like you need to decide to transfer or to allocate the responsibilities among the players that are participating in any given development. And for example, we see a lot of clients nowadays, a lot of startups thinking that just because they come and they will say, I want to be the Uber of medicine. And then when they elaborate a little bit more, they use concepts such as, yes, just a marketplace, just going to be a marketplace. And so therefore, I'm expecting to be able to transfer all the compliance liability to, for example, the physicians that will participate in the platform. And they will be the responsible on about complying with different aspects of the health regulation. We have to explain that it doesn't work exactly like that. It also depends on what do you say you're doing. If the platform is saying that it's providing telemedicine services, is billing you for that, and so on and so forth. So you're getting closer to saying that, well, you are the one providing it. So you are acquiring or attracting some regulatory attention in that regard. So this relates to the point of how to reflect into the commercial agreements this issue of the allocation of responsibilities, and the players need to understand that there is also a compliance trend here at place, where you can no longer claim that you complied with what was your part of the deal, and that you knew that the other one was not complying, and hope that you're not going to get in trouble. So you're more and more expected to know what the others' responsibilities were, so that you're engaging into an environment of compliance, right? So, and that means understanding where are the risks for everybody, not just for you. And unfortunately, we see a lot of clients that would like to understand just their tiny bit. And more we see that, no, you need to understand more about what the others will do as well.
Now, that raises something interesting points. Now, before we go into the Q&A session, I was going to ask one last question related to something to what you said right there, Christian. Again, this issue of compliance, regulatory compliance is huge, right, for the space. How do you view these non-traditional healthcare players that are kind of piling on, right, in the space in the past couple of years? I would say players are not used to dealing with healthcare authorities who may, like you said, have this really kind of like idealized construct of how they fit in and why they actually should be outside of the regulatory authorities. I mean, I'm curious as to the broad group's thoughts on these non-traditional players who are beginning to file into the space, and good, bad, or any type of advice you can give those companies.
Yes, we see. It's fascinating that there are two communities that are interacting in digital health: those that come from the digital side of things, and those that come from the more traditional healthcare side. And you see that in the way they approach the discussions, the framing of the issues, and the way they see their model, their business model. And at the end, it's an issue of risk aversion or familiarity with the risk. The players that come, what we see is that players that come from the digital side are very comfortable in scenarios where there is no regulation, or the rules are not very clear, and they will expect to be able to, so they would regard that as an opportunity to enter the market quickly, and then deal with the decisions of, with interventions of the regulator when and if they come. And whereas those players from the healthcare, more traditional sector would be more risk adverse and would see the lack of regulation or lack of clarity in the rules as something that needs to be attended. It's not something that needs to be addressed quickly, perhaps entail a ruling request from the regulator. They want to explain to the regulator. And the other community does not want to go and talk to the regulator. They will say like...
Is this simple as proactive versus reactive approach?
Yes,
would you say?
Absolutely.
Yeah.
And that's fascinating to watch.
Yeah.
And we're there to navigate that, to help them navigate that, of course.
Great. David or Lincoln, any thoughts on that before we go on Q&A?
I think that the point made is interesting point. I think one thing is very important to recognize is that the regulation is not there to stop people producing goods or marketing goods. I think that there's an enabling component of the regulation, a clarity of the regulatory requirements actually set the target and the goal. So long as the goal is not moving go, and for people to meet the requirements, trying to bypass and circumvent the requirements actually will set the whole sector back. If anything goes wrong, we have seen many problems associated with one or two bad apples within the community actually set the entire sector into disrepute. We have seen that in the medical devices sector. We have seen that in the pharmaceutical sector. In the last 2-3 years, the UK had one of the biggest health safety review as a result of certain mishaps associated with drugs being prescribed and devices not properly constructed, leading to very serious personal injuries, resulting in government initiating this major review. And most recently in Europe, for example, the complete reform of the medical devices regime is in direct response of the mishaps associated with the mismanagement of devices. So I think that the lessons to be learned from those issues. But turning to the point about AI and machine learning, I think that it will require us to adapt the conventional approach of risk management to this kind of technology. The scary bit of the AI is not about the technology itself. The scary bit is the initial construction of the algorithm based on the source data you derive from. And the integrity and the quality of the source data will inform whether or not the algorithm is properly constructed, the assumptions you have made. And that may have the potential of leading to the wrong outcome, the wrong readout. The scary bit is actually, even though you've got the algorithm right, for adaptive AI, the machine actually self-learn, and that has little human intervention. That is a scary bit. Is how you're going to control, how do you ensure there is proper oversight? We have no idea at this stage, but I think it's important that actually we have to adapt the conventional risk minimization approach to control what we do not know. It's not what we know we are interested in, what we do not know. That is frightening.
And that's interesting you brought up, because AI doesn't have context. Doesn't have context to the data. It takes the data at face value. So there's no principle underlying how those models are built out, especially on, like you said, the generative piece. But that's a very interesting point, Lincoln. I think we're down to the last couple of minutes. I want to open it up for questions. James, you have any questions from the audience, or?
Yes, thank you, Roger, and thanks to everyone on the panel for that stimulating 55 minutes. Much appreciated. If you're watching and you have any burning questions, do submit them in the chat box. I have one, and actually this is more of a market question, and I think it's best posed to David, if you don't mind, David. The workforce in digital health, how's things going to play out, do you see at the minute? You know, we've seen this huge expansion of the industry. Yeah, is there enough people? Is there enough scientists, data engineers, software developers, clinicians, you know, or are we going to hit a roadblock, so to speak, you know, in the coming years as this continues to progress?
Yeah, I think it's not going to be for lack of people resources. There's an amazing amount of domain experts out there. So it's not just people steeped in the arts of mathematics and consumer science. What really drives the technology is a fundamental understanding of the domain. And then the rest of us who are the computer scientists or the double-E's of the world and the mathematicians, we can augment that. So as long as the domain keeps growing, which I think it will, the translational piece will be fine. And I think we'll be in really, really good shape.
Great, thank you. I've got a question here, and Roger, you've asked all the questions, so let me ask you one. This comes down to geopolitics, and simple question is, again, do you see the geopolitics, you know, around the world being the major disruptor to the continued progression of the industry, you know, over the coming years again?
That's a very interesting question. I do see it playing a part, and in part with some of the, I guess, issues that are, at least points that Lincoln made earlier, which is the value of these models really is in the data, right? How these data, the access to the data that's used to go and build these models out. Frankly, you know, I'm primarily served on the IP side, and I have yet to see a lot of the innovation in the AI machine learning algorithm itself. I have seen how innovation in terms of how it's applied and how, you know, maybe some of the ways that you would go pre-process data, the data that goes in the model. So really a lot of the core sources of, I would say, what drives these algorithms to work well is really an access to this data. And at some point, it's not even going to be, for example, geopolitical from a factions perspective. There is actually going to be an advantage to that. For example, in the UK, I raised it earlier. They have heterogeneous data and a lot of and a very homogenized back end electronic medical records that are attached to it. That data set is extremely uniquely valuable in a lot of ways. And I could totally see an instance where, for example, the UK could find a way or see it beneficial to benefit domestic players and giving them unique access to that data to give them a leg up. So I see those things happening, frankly, at some point.
Excellent. Thanks, Roger. And look, we've run over the hour by a minute or two. So I think we're best to wrap up here. Look, if you've got any questions, queries, do reach out to us, do reach out to the panel members with those queries, with those questions. I'm sure they'll be happy to field them and take them on. All that's left but for me to say is thanks again to Roger, thanks again to Lincoln, Christian and David for joining today. We really appreciate the time and of course passing on your knowledge and your opinions. So thanks very much for that. And to everybody watching, do stay in touch with us, do keep returning. We're going to be doing more of these and we're going to be continuing to progress the quality and the coverage of our flagship International Comparative Legal Guide to Digital Health as well. So thanks again to everybody. We hope to see you soon.